I will be talking about consideration. Consideration is defined under Section 2D of the Indian Contract Act. It is defined as when the promisee, at the desire of the promiser, had done or abstained from doing something, has done or abstains from doing something, or promises to do or promises to abstain from doing something, then such act or abstinence is called consideration. Now, coming to certain requirements which are necessary for anything to term it into consideration is that it could be past, present, or future. The consideration must always move from the desire of the promiser. Then it could be an act, an abstinence, or even a promise. Then it need not to be adequate, but it has to be of some value. Then it has to be real and not illusionary. It must be lawful and it must not be against public policy, or it must not be immoral. It is a general rule that the consideration must move at the desire of the promiser, and the contract can be enforced only by the party to the contract and not at the behest of someone who is stranger to a contract. However, there are certain exceptions to this. That is, if there's a contract of marriage, if there is an acknowledgement of estoppel, or there's covenant running with the land. Now, coming to past consideration, in English law, past consideration is no consideration. However, this rule has given rise to some of the inconveniences in the English contract law, and therefore in the law commission released by England, there was a proposal to remove this kind of rule. However, in India, a past consideration is a valid consideration. In fact, a past act which is done at request is to be considered as a good consideration. One of the important aspect which is mentioned under Section 25 Clause 2 of the Indian Contract Act is in regards with the past voluntary services. So if a person does anything without the request of the other party or without any promise from the other party, and the other party in turn promises to pay the person who has done the act, then that promise need to be kept, and this would be treated as a good consideration under Indian Contract Act. Now, talking about executory consideration, so this could be explained with the help of an example. So, for example, A promises B that he will give him the money if he sells him some good. So, until the point of time A does not receive the good, the consideration is executory. However, if B gives the good and A pays for the good that B has sold to him, then that consideration would be termed as executed consideration. Now, many of the people have the myth that the consideration should be adequate, but that is not so. The consideration should be of value, of course, but it is not important that it is to be adequate with the thing it is in regards to. So the court would not judge the value of the goods. If the party considered it to be valuable, then it's enough for the court. And this rule is applicable both in the Indian law and in the English law. Now, talking about performance of a legal obligation, a person who has undertaken to do something which he is already bound to do by law, this won't be treated as a good consideration. However, if he has chosen to do it in a way which is different from what the law prescribes, then it is a valid consideration. Also, if the promisee undertakes to do something which he was already bound to do as per the contractual obligations, then that would also not be considered as a valid consideration, because then he would not be extra bounded to do certain things which the contractual terms ask him to do. Moreover, promise to pay a sum which is less than the sum which was agreed is also not a good consideration. This rule came in the case of Penny versus Cole, also famously known as Pinnell's case. In that case, it was held that a smaller amount cannot satisfy the whole of the debt, so that's why a smaller sum is not a good consideration. However, there are certain exceptions to this Pinnell's case, like the composition, promissory estoppel, and part payment by the third party, and payment before time. Now, I would conclude this topic by saying that consideration is defined under Section 2D of the Indian Contract Act, and it could be past, present, or future. And consideration need not to be adequate, but it must be of some value. The value must be ascertained according to the parties, and moreover, there are certain exceptions that are present under Section 25 of the Indian Contract Act. These are natural love and affection, past voluntary services, and time barred debt. These exceptions are made to acknowledge and to make a leeway for certain circumstances that may arise during the course of contract.